For 4 decades, one strategy has shielded the center of this organization from direct accountability. It has worked through lawsuits, audits, congressional inquiries, and civil investigations. The strategy is simple: distance. The person at the top does not touch the details. He delegates. He relies on others. If something goes wrong, responsibility stops below him. That framework survived because it depended on loyalty and silence. This morning, that framework failed. At approximately 10 o'clock, during sworn testimony, Eric Trump was asked a question that had been engineered to collapse that entire structure. This was not a press moment. No cameras, no speeches. This was a deposition under oath, where every answer carries legal consequences. For months, witnesses had relied on the same defense. "I don't recall." It is a phrase designed to protect memory and avoid contradiction. It is not illegal, but it only works until documentation appears. Prosecutors did not rush this moment. They spent weeks building the record. They confirmed signatures. They established authority. They locked in who had approval power and who merely executed instructions. Only after that foundation was set did they ask the question that mattered. It was not about fraud yet. It was about verification. The question was direct. Did you personally confirm the accuracy of the financial statements before they were finalized? At first, the answer followed the expected path. Reliance on professionals, accountants, advisors, standard corporate language. That answer alone would not have changed the case. But prosecutors did not stop there. They introduced a document bearing Eric Trump's signature. They asked whether he had authority to approve valuations reflected in that document. That is where the testimony shifted. Because authority creates responsibility, and responsibility creates exposure. Eric Trump did not deny authority. He acknowledged it. Then, without pause, he explained why he believed signing was appropriate. His explanation was not defensive. It was explanatory. And in explaining his role, he made the statement that now sits at the center of this case. He said he verified everything with his father. He said his father was aware of each deal. He said nothing was finalized without that confirmation. That sentence was not framed as accusation. It was framed as justification. He was explaining why he believed his actions were proper. But legally, that distinction does not matter. What matters is what the statement establishes. It connects approval at the operational level to knowledge at the top. It removes the argument that decisions were isolated or delegated beyond awareness. It collapses the insulation layer that had separated the organization's leader from the execution of transactions now under scrutiny. In that moment, plausible deniability ended. The defense has argued consistently that the former president was removed from valuation mechanics, that he trusted others, that he did not engage with numbers. This testimony contradicts that position under oath. It does not suggest occasional awareness. It suggests routine confirmation. Defense counsel understood immediately what had happened. This is the kind of admission that cannot be erased by clarification. It lives in the transcript. It will be read aloud. It will be compared against prior statements. Jurors do not weigh explanations the way lawyers do. They weigh consistency. The importance of this moment is not emotional. It is structural. Civil fraud cases rise and fall on intent and knowledge. If the decision-maker knew the representations were false and approved them anyway, liability expands dramatically. What happened this morning did not prove fraud on its own, but it removed the barrier that had prevented prosecutors from arguing direct involvement. That is why reactions escalated so quickly. This was not about politics or optics. It was about control of the narrative being lost in a single sentence spoken under oath. Once that happens, the case moves forward whether the defense is ready or not. To understand why this admission carries such weight, you have to understand how white-collar defenses are built. In financial cases, prosecutors must establish intent. It is not enough to show numbers were inaccurate. They must show the inaccuracies were knowingly approved. That is where executive distance becomes a shield. If the person at the top can plausibly claim ignorance, intent becomes difficult to prove. For years, this organization relied on that shield. Executives handled operations. Accountants prepared statements. Lawyers reviewed filings. The person at the top positioned himself as a brand manager rather than a decision maker. That narrative only works if everyone below maintains it consistently. The moment a witness breaks from it under oath, the entire structure becomes unstable. Eric Trump's testimony did not introduce new documents. It introduced a new interpretation of authority. By stating that valuations were verified with his father, he reframed the decision-making process. He moved approval upward, and once approval moves upward, responsibility follows. This is not a question of loyalty or betrayal. It is a question of exposure. Witnesses under oath face two risks: perjury if they lie, liability if they admit too much. Most attempt to stay in the middle. Today, the questioning eliminated that option. The witness was forced to choose between personal protection and institutional protection. He chose himself. That choice is common in complex investigations. It is not malicious. It is human. When the risk of criminal exposure becomes real, people explain their actions truthfully, even when those explanations harm someone else. Prosecutors understand this. They design depositions accordingly. The legal concept at play here is imputed knowledge. In civil conspiracy cases, knowledge does not require direct instruction. It requires awareness and approval. If a leader knows of conduct and allows it to continue, liability attaches. The testimony today provided prosecutors with a pathway to argue exactly that. This changes the scope of the case. Previously, the focus was on inflated valuations as a product of internal mismanagement. Now, prosecutors can argue top-down approval. That distinction affects remedies. Courts treat isolated misconduct differently than coordinated schemes. Remedies expand when leadership involvement is established. Judges are not required to accept insulation arguments when evidence contradicts them. They have authority to appoint monitors, dissolve entities, freeze accounts, and revoke licenses when fraud is found to be systemic. Today's testimony supports that framework. There is also a downstream effect. Civil transcripts do not remain confined to civil court. They are discoverable. They are admissible in other proceedings under certain conditions. If federal prosecutors are examining potential criminal exposure related to financial institutions, this testimony becomes relevant. Bank fraud requires proof that false statements were knowingly submitted to obtain funds. Intent is the element that separates poor accounting from criminal conduct. The admission that valuations were verified at the highest level strengthens that element significantly. This is why the defense reaction has been so aggressive. The filings, the public statements, the attacks on process. These are not signs of confidence. They are signs of a strategy adjusting under pressure. When a defense pivots this sharply, it usually means something fundamental has changed. The most difficult position now belongs to the person at the top. The testimony creates a contradiction. To preserve his defense, he would need to deny his son's account. That creates its own risks. Conflicting testimony within a family damages credibility. And if the former president testifies, he exposes himself to cross-examination. That is the dilemma created by a single sentence spoken under oath. It does not end the case, but it removes the safety net. From this point forward, every argument must account for that admission, and that is a much narrower path to walk. This is not the first time this pattern has appeared. In family-run organizations, loyalty is often treated as a legal strategy. Positions are filled with relatives not only because of trust, but because silence is expected. That approach works until legal pressure forces individual calculations. History shows that when those calculations begin, structures unravel quickly. Previous investigations involving this organization followed a similar arc. In charitable and educational ventures, family members were placed in governance roles. When regulators intervened, those same family members became witnesses. The result was dissolution, penalties, and admissions that contradicted earlier public narratives. What we are seeing now is that same process scaled up. The critical mistake in relying on family insulation is assuming uniform risk tolerance. Different individuals face different exposure. When prosecutors present potential consequences clearly, memories sharpen. Explanations evolve. The oath changes behavior. Eric Trump has participated in depositions before. He is familiar with legal process. The fact that he answered this question directly suggests that the pressure has reached a point where ambiguity is no longer sustainable. That does not indicate recklessness. It indicates calculation. It also suggests that legal counsel for different members of the organization may no longer be aligned. In complex cases, defendants often receive individualized advice. What protects one person may endanger another. When that divergence occurs, collective defense strategies weaken. The immediate legal consequences will unfold in stages. The court overseeing the current case now has sworn testimony establishing senior-level knowledge. That affects rulings on remedies and oversight. Independent monitors become more likely. Asset controls become easier to justify. License revocations become plausible. Beyond that, investigative agencies pay attention. Civil cases often serve as evidence-gathering tools for criminal inquiries. They lower the barrier for future action by establishing facts under oath. This is not speculation. It is standard practice. None of this guarantees criminal charges, but it changes the risk profile dramatically. The defense must now prepare for outcomes that were previously avoidable. That includes preparing for testimony at the highest level. What makes this moment significant is not its drama, but its permanence. Depositions are recorded. Transcripts are immutable. No amount of messaging can erase sworn words. The record exists independent of spin. This is how accountability advances in complex cases. Not through a single explosive revelation, but through incremental erosion of defenses. A sentence here, a document there, a contradiction that cannot be reconciled. Today's testimony did not convict anyone, but it clarified who knew what and when. And in legal proceedings, clarity is dangerous for those who rely on ambiguity. As this case continues, filings will multiply, motions will be argued, remedies will be contested, but the foundational issue has shifted. The question is no longer whether leadership was insulated. The question is how deeply involved it was. That shift matters. It changes leverage. It changes timelines. It changes strategy. And it happened not because someone intended to expose anyone else, but because the oath demanded an explanation. And the explanation revealed more than intended. This is the moment when a defense stops being theoretical and starts being reactive. And once that transition occurs, outcomes become harder to control. I will continue following this case document by document, testimony by testimony. Subscribe if you want analysis grounded in records rather than rhetoric. And tell me in the comments, do you think this admission was a mistake, or was it the truth finally surfacing under pressure? Because in this system, those two things are often the same.